Okay, thank you.
Justice Sotomayor?
That doesn't seem consistent with Edwards, where
I
the
think
prisoner was in custody and
I
where
think
we
there
said
would definitely be some tension there, Justice
a
Sotomayor.
lot of tension.
I don't deny that.
I want to I want to understand your argument, or at least simplify it in my own mind as I have, okay? Heck itself, and you have to put it in context, was a malicious prosecution claim. And you said to prove that element, you had to prove that the prosecution itself had been malicious. And the court there said the cause of action is the prior conviction. And so you can't bring this by 1983, correct?
Yes, Your
Yes,
Honor.
it's bringing
because
in
one of the elements would require favorable termination of the prior conviction.
Exactly. And the same thing with Edwards. If he won, alleging defects in his disciplinary proceedings, that would undo the good time credit that was revoked. So one of the elements was to prove that that revocation was necessary, correct?
Correct.
What you're saying, I believe, is if the claim does not rely on any facts of the prior conviction or anything involving the prior conviction or its proceedings, then it's purely prospective, and that the prisoner should be permitted, that the defendant should be permitted to bring.
Yes, thank you, Your Honor. Yes.
It's
Thank
almost as simple as that. I think where some of my colleagues may be hung up, and I was actually too when I read the heck language, is the heck language is very broad. It basically says if it calls into question language. By definition, a win by you or a win by a third party would call the prior convictions into question. And so that line is not very, by you parroting or trying to deny that line, doesn't help. It does call it into question. It will be used by you and others to try to go back in other proceedings and get those expunged or otherwise set aside. You may or may not win, but it will call it into question. So I guess what Justice Alito started with was saying to you, do we have to disavow heck? And so I want to narrow this and the question to saying, does a ruling according to the line we just spoke about earlier, which is prospective relief that doesn't on its own rely on the prior conviction or undoing the prior conviction, doesn't directly call it into question?
No, and it doesn't. And I think you can't construe necessarily implies in isolation. I think the surest guide for what necessarily implies the invalidity of a prior conviction means is to look at how this court has applied it in case after case. And this court has only held a claim or relief heck barred in, there's two buckets. The first bucket are claims where the federal relief would result in immediate or faster release from confinement. The second bucket is damages resulting from past confinement. Those are the only two buckets of claims where this has applied heck. And I think when you look at how this court has applied the necessary implied languages, and I think it's significant that Justice Scalia who authored heck was in the majority in all of this court's heck cases while he was on the court. So I think that has a particular pedigree in terms of how this court has approached it. And so Mr. Olivier's claims for wholly prospective relief clearly don't fall into either bucket of cases or relief where this court has applied heck. So in our view, what we are saying is perfectly consistent with the language of heck as this court has applied it in case after case.
Thank you. Justice Kagan?